I want to talk to you about something where there's a lot of misunderstanding among both the buyers and the sellers. Hi, I'm Gordon Baker with RE/MAX Alliance Group, and I want to talk to you about contingencies in the real estate contract. Now, the Arizona Real Estate Purchase Contract contains certain contingencies, meaning events that must be satisfied for the sale to move forward, or allows the buyer to cancel the contract. Probably the most well-known one is the inspection contingency. This is the opportunity for the buyer to perform the necessary inspections and due diligence about the area. And not just the house, but the neighborhood, schools, crime statistics, and anything that is of a material nature to the buyer. The Arizona Department of Real Estate Buyer's Advisory is an excellent resource. Now, at the end of the inspection period, the buyer can elect to, number one, accept the premises as is, number two, cancel the contract, or three, proceed with the sale based on the seller addressing certain issues that may have come up during the inspection process. The least thought of contingency in the contract is the one associated with the title commitment or title report. In the title commitment, you'll be made aware of any deed restrictions, easements, and rights of way. Recently, I helped a buyer get an offer accepted on a property that had an SRP easement that prohibited constructing or having a building on almost half of the 1 acre property. Unfortunately, that was why the buyer wanted the property, is to put an additional building. That escrow wasn't open very long, and a buyer has 5 days after receipt of that information to provide notice of any items disapproved, which is really an interesting way of saying they can cancel the contract. Next is the HOA addendum and contingency. The HOA addendum discloses the information that must be presented to the buyer by law. This information will include the CC&Rs, bylaws, an HOA operating budget, the most recent financial statements, and if available, a reserve study. Again, the buyer is allowed 5 days after receipt of this information to provide written notice of any items disapproved. Again, that funny way of saying they can cancel the contract. Another contingency which has a higher visibility is the appraisal contingency. The property must appraise for at least the sales price. If it fails to appraise, the buyer and the seller have 5 days to work something out. Otherwise, the buyer can cancel the contract. And one of the last contingencies, maybe the most important, is the loan contingency. The buyer must make a diligent and good faith effort to obtain a loan. If after making a diligent good faith effort to obtain a loan, they are unable to obtain loan approval, they can cancel the contract and receive a refund of the earnest money. This is why it is so important to make sure the buyer is pre-qualified through a good loan officer and request weekly loan status updates that show the status of the loan while it's in escrow. I hope this has been helpful. For further information and details on the contingencies contained in the contract and other addendums, please reach out to me, Gordon Baker with RE/MAX Alliance, 480-326-8571. Thank you.